one of the proud promises of the civilized world has always been law, order, peace, and discipline, have long formed the basis on which countries were classified as first world or third world.
People in the West are a little bit tired from the decades of peace, democracy, wealth, and freedom. It is for themselves a little bit boring.
Administrative justice in Ukraine is a sphere in which the resilience of the rule of law is tested on a daily basis.
The Supreme Court of Sri Lanka found the former executive of this country liable for breach of constitutional duties. Rule of law has been advanced in its full plenitude in Sri Lanka.
Even the highest office be subjected to constitutional scrutiny.
We are judges, we are not political actors, and our duty is to protect the rights and the law under the Constitution.
Across Europe and indeed globally, narratives questioning the legitimacy of courts have intensified. The chilling effect of this type of action against the judges is a red line not to be crossed.
In Hungary, judges are not allowed to express political views.
Why is defiance of the rule of law gaining political appeal across the world?
Rest assured that the judiciary holds the final move.
We can uphold the rule of law only to a limited extent by our judgments and opinions, but we do not have means to enforce them.
Politicians must not interfere with the substance of judicial decision, but the organization and financing of the courts is a democratic issue too.
For one, never ever give up.
We simply need an openness to listen.
Thanks to Global South Network, which allow us to believe in a better world of the rule of law.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Reayat, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Allow me to invite our next discussion, the Honourable Justice Professor Dr. András Varga, President of the Curia Supreme Court of Hungary.
Honourable President, Honourable Madam Justice, judges, esteemed participants, their professors, their colleagues, let me begin my contribution by thanking Dr. Nauman Reayat for creating the opportunity for this particularly interesting dialogue. This event enables us to exchange experiences and share our thoughts with each other. I listened with interest to the lecture delivered by President Kari Kuusiniemi, and what he said confirmed in general my belief that the importance of the judiciary remains unquestionable in the functioning of a constitutional state and in maintaining of rule of law, or the principle of Rechtsstaat, because this is more common in Central Europe. And of course, it's very, very important from the point of view of public trust. In this context, I would like to share some observations with you. I will not react to the issue of liberal or illiberal shape of democracy. I will not, because this is not a legal, and what more, not a jurisdictional, but it's a political issue. And in Hungary, judges are not allowed to express political views. This is one of our version, our way how we interpret rule of law and separation of powers. The provision of our constitution called fundamental law on the independence of judges also emphasizes that judges shall be independent and subject only to the law, and no judge could be instructed in relation to our judicial activities. This regulation is particularly important and relevant in the light of recent misunderstandings in Hungary regarding the so-called solidarity contribution. Perhaps solidarity tax is much more common, but formally is not a tax, is only a tax-like contribution. In respect which it should be stressed that the Curia, the Supreme Court of Hungary, is a cassation court. Consequently, the Curia shall decide on a case only when it is referred to it, after it is concluded at the level of lower courts. And the Curia, as a Supreme Court, cannot instruct lower instance courts in their ongoing cases. So this is the reason why we couldn't react to this problem of solidarity contribution was, or how it was introduced in the Hungarian legal system, and the content which ruled that all the pending cases should be finished. So the Curia therefore did not take any position on this government decree. First instance judges referred this case, some of them to the European Court of Justice, others to the Constitutional Court of Hungary. It is a fact that an emergency government decree may contain, in general, provisions that can be contra legem, so can be in line with the laws, with the acts of the parliament, or praeter legem. And this was such a decree. It was an emergency decree. But whether it was constitutional or not, we will see. So the Curia, the Supreme Court, had no pro and no con opinion regarding this, because we didn't got any file from lower courts. If we got, of course, we will decide. Esteemed colleagues, if I started with this, in the following I will share very, very shortly or briefly some thoughts on two major topics related to the administration of justice: the case law uniformization. Dr. Reayat knows that this is one of my favorite questions, and the adjudication in electoral cases. As regards the case law and uniform application of laws, mechanisms that ensure consistency in judicial practice play a key role in legal certainty and predictability of the judiciary or of the judicial decisions. In this regard, Hungary applies a unique model based mostly on the continental or so-called continental legal tradition, but which also incorporates the logic of the Anglo-Saxon precedent system or stare decisis theory. We call this limited system of precedents. Some weeks ago, I had the privilege to present its functioning and details at this channel. The other question, what is just in these days our apex task, is the adjudication in election cases. It is interesting that even if I mentioned that the Curia, the Supreme Court, is mainly a cassation court, in election cases, the Curia, the Supreme Court, is the first and last instance court. This is interesting. There are some countries which follow this model, but it's a special situation regarding other matters of law in Hungary. Electoral adjudication is difficult because it must demonstrate that law is capable of creating finality, and even the losing party may and can accept without viewing the court as an enemy. In electoral cases, this is very, very difficult. I used to say that practically the role of a court is to find the conflict between parties, to transform the social, family, commercial, or even political conflicts into legal debates. This is the main role of the courts. But of course, this is difficult in commercial cases where a lot of money is questioned. This is more difficult in family cases where the question is very personal, but it's also very, very difficult when it's regarding election where the conflict of the political parties is crucial for them. And we have to transform this conflict, which during the campaign, it's what you see if you open the internet, what happens in a country during the election campaign. And our role is to refine it, to domesticate it, like we did thousands of years ago with animals, to do it, to make it possible to have a debate on legal arguments and to try to achieve a solution, a decision where even the losing party, and party in double meaning, the political party and party in our trial, can accept it. So this is why these days are really difficult for us. But if we do it successfully, then we demonstrate that rule of law is not only a theory, but it's a part of the everyday existence in a constitutional state. So dear colleagues, this was my contribution, and I would like to thank again for creating this opportunity, and congratulations for the Global South Network to engage in dialogue. And as the president of the Curia, we are very proud that we are one of the oldest Supreme Courts in the continental Europe. We are always ready to cooperate in the different topics. Thank you very much for your kind attention.
Thank you very much, the Honourable Justice Professor Dr. András Varga, President of the Curia Supreme Court of Hungary, for delivering your response. And we are also proud of engaging you, having a collaboration with you consistently. This is the second time we are having you, so it's really refreshing.